Coexistence agreements are often sold to founders and mark owners as a calm, reasonable compromise or solution, right? So you can avoid lawsuits, you can avoid having to rebrand, you can avoid a lot of drama and the associated expenses with a dispute. Just two businesses agreeing to live in peace and harmony side by side. But today I want to talk about what happens when coexistence goes wrong, because I've seen it derail otherwise strong companies in ways that founders never expected. And by the way, if you want to understand more about what a coexistence agreement is or a consent agreement, I have done two previous videos. You should jump into those to get that background to understand what they are. But today we're going to talk about how they can go wrong. The most dangerous thing about a bad coexistence agreement isn't that it's going to create problems immediately. It's not going to just explode or implode right away. It works for a while generally until it doesn't. And so let me start with a common story. A founder receives a cease and desist letter from another mark owner. And after some back and forth, the other side offers a settlement or resolution through what's called a coexistence agreement, where the two marks are going to live side by side in peace. And on its face, the agreement seems reasonable to the founder. It limits a few things, but nothing feels urgent. And the founder signs it, relieved to have avoided litigation, relieved to be able to move on with their business. Fast forward a few years, and that business is now growing, and the founder is launching new products, new market opportunities are opening up. And suddenly, the terms of that coexistence agreement become a total barrier to growth into some of those spaces because it limited those things. And the founder realizes that they contractually agreed not to do what their business now needs to do. And if they pursue these opportunities, they're going to be in breach of contract and again, face the risk of litigation with the other mark owner. This is one of the most common coexistence failures that I see. An agreement that basically freezes your brand in time and prevents future growth. And unfortunately, prevents it at a time that you probably really need it to be happening, the growth. At the moment of signing, a business owner will often underestimate how fast their businesses might evolve. And a restriction that feels narrow today, it can become crippling tomorrow, especially in the world with tech and AI and sort of the exponential growth that we're seeing with businesses and the growth of new product and service lines and ability to deliver products and services in new ways that didn't exist even 3 years ago. Another failure scenario is channel expansion. I've seen coexistence agreements that prohibit selling through certain platforms or prohibit advertising through certain channels or even in geographic regions, not just advertising, but operating in different geographic regions. And at the time, the founder who signs those limitations in the agreement isn't using those channels. And so it doesn't feel like that big of a deal. It's a compromise they're willing to make in order to be able to use the brand they want to use and not have to rebrand and go through that whole hassle. But later, the market shifts or consumer behavior changes or there's a new technology and the founder discovers that they've locked themselves out of critical growth paths. Then there's the enforcement problem. Many founders assume coexistence means peace forever, but it doesn't. It's just a contract. And if the other party slowly creeps beyond the agreed boundaries, for example, enforcement becomes important, but also complicated. You're no longer dealing purely with trademark law. Now you're dealing with contract enforcement, a breach of contract and legal claims under that contract. And that can mean more cost, more ambiguity, less leverage than a clean trademark dispute. And other major coexistence failures can involve the weakening of trademark rights. Some agreements unintentionally admit that confusion is likely between the two marks, or they allow overlapping use without strong safeguards, which overlapping use of two potentially confusing marks actually weakens the strength of both of those marks. And that can really come back later to haunt a founder when they're trying to enforce their trademark against a different third party or defend their registration with maybe there's a conflict with a different third party. The existence of the coexistence agreement can actually have a estoppel effect. It can be used against them in those other disputes. So we need to talk about consent agreements specifically in this context, because we've got coexistence agreements, which is where the parties agree to coexist. Then we have consent agreements where A senior mark owner is consenting to a junior mark owner's use of a very similar mark, but it's going to have some real limitations within that agreement for in exchange for that consent. Consent agreements can be effective with the USPTO if they're done correctly, but poorly drafted consent agreements often fail because they don't actually address the potential of confusion between the two marks. And once they're filed, they become a part of the public record. Then you're on record as having agreed to this coexistence as the senior mark owner. And I've seen founders surprised to learn that that consent agreement that's now on the public record that they signed years earlier is being cited in a later dispute by another third party to argue that their trademark isn't strong and is not exclusive. Under the Trademark Act, when you acquiesce to or agree to another party's use of your mark, that acquiescence can ultimately become a waiver of your own trademark rights. You have to be so careful that by entering into a consent agreement, you're not actually waiving or weakening your rights and your ability to enforce your own mark. That can be extremely costly to your business. And that's why coexistence and consent agreement failures can be so painful, because at the time, they don't feel like mistakes. They feel like they're a compromise, and you feel like you're maybe being smart, avoiding litigation. But here's the harshest truth about it. Sometimes coexistence or consent is offered not because it's fair, but because the other party actually knows that it benefits them more than it benefits you. You have to really understand worst case scenarios when you look at the agreement terms. This is why the decision to coexist or decision to give consent should never be rushed. A trademark lawyer's role isn't in this scenario is not to say yes or no reflexively. It's to stress test the agreement against your future, against your plans, and against the strength of your mark even now. A good trademark lawyer is going to ask questions like, what happens if you double in size as a business? What happens if your product line expands or you go in a complementary direction? What happens if the market changes or new technology arises? How limited are you going to be in your ability to expand as a business? And are you going to be breaching that agreement? Are you going to actually end up in litigation again as a result of the terms that you agree to? I've helped founders renegotiate coexistence agreements that were headed for disaster. I've also helped founders walk away from agreements that would have quietly but firmly boxed them in for a decade or longer. And in many of those cases, the founder later told me they were relieved they didn't just sign and make the problem go away. Here's what I want you to take away from this episode. Coexistence and consent agreements don't fail because you're being careless as a founder. They fail because you're being optimistic. And as I said, optimism is great, but it's not a legal strategy. These agreements can work, but only if they're crafted with a clear understanding of trademark law and contract law. If someone proposes coexistence or consent to you, or if you're considering offering it, that is not just paperwork. It's a moment where you really have to consider the strategic reasoning behind why you would offer it and what is your leverage in this situation between you and this other party. It's worth slowing down and asking these questions. If you're facing this type of decision and you're not sure whether it's protecting you or limiting you, this is exactly the kind of issue that benefits from careful legal analysis and guidance upfront before you sign anything. Because the most expensive trademark mistake isn't always a lawsuit. Sometimes it's the agreement you sign to avoid the lawsuit. If you want help with this, just schedule a call with me and we can talk through your specific situation. I can help you figure out what the next best steps are for you and whether you should be seriously considering this type of agreement, or whether maybe we should be approaching either enforcing your rights against a junior mark holder or a rebrand if you're the one that's in that situation as the junior mark holder. Give me a call and we can work through this together. Make sure that you're protected and your future is safeguarded.